with copyright? Good. Okay. So yeah, I've talked about copyright on campus for most of the time I've been here, which is about 13 years. I will start by saying I am not a lawyer. I'm not a copyright lawyer. I just have had a lot of training being in my role as a librarian and the things that I interact with, being scholarly communications and publishing and that type of thing. When I talk about copyright, I always have to talk about what copyright is not. And usually often people will confuse copyright and plagiarism. So I just like to pause and say that when we talk about plagiarism, we're talking about something where we're passing off another person's work as our own. We're claiming something that's not ours as our own. And so that's a moral and ethical issue. Whereas copyright is actually an infringement and a legal issue, right? So we're infringing on someone else's rights. So we're violating someone else's copyright, and that's actually a legal issue. And so that's why I'll go into a little bit of depth about what copyright law is, but then we'll talk more about what we can do with copyright and those types of things. So again, when we're thinking about plagiarism and fair use, plagiarism, copyright and fair use, plagiarism really falls under an academic misconduct. So if you plagiarize, you can be expelled or put on probation. You are violating potentially ethical codes of your profession, or when you submit an article to a journal, they will check your work to make sure it's not plagiarized against someone else's work. And so it really is something that affects someone's reputation and whether you're a good standing as a student. Whereas using copyrighted materials through things like fair use really becomes down to a legal issue. And so there are legal ramifications if we violate copyright, and figuring out where we fit within that law is a little bit trickier. But as we become authors and we publish in journals, we also are copyright holders. So we need to understand how our own work is protected and what clearance we're giving. I mean, again, it actually does connect with some professional and legal codes of conduct when we think about our copyright and whether we're sharing copyright with a co-author and those types of things. So when I say codes of conduct, it may be the first time people have kind of heard of that, but different disciplines and associations actually have these, what they call ethical principles or ethical codes of conduct. So I just highlighted a few here. There's the psychologist, the education, I think the neuroscience, engineer. So there's a couple of them there. There's links. I will make the slides available with all of this after the presentation. So it's good to know if you're just kind of learning about these, where you fall in there, what potential association you would be aligned with and what their ethical codes are. And a lot of these codes actually speak to authorship when you're authoring a journal article and how authorship is determined and that type of thing. So when we're thinking about copyright, it actually comes underneath a constitutional provision. And so I kind of, I have a nice graphic there of what it looks like in the Constitution. But essentially what it says is that Congress shall have the power to promote the progress of science and useful arts by securing for limited times the authors and inventors their exclusive, and I can't see the rest of it because my bar's over there, sorry, their exclusive rights to their respective writings and discoveries. Okay, so a lot of legal mumbo jumbo, but it will make clearer sense as we move along. So you'll hear copyright talked about as Title 17 of US Code. Okay, so the way that US laws are written, they have these numbers that are attached to them. And as I said, it's a federal law that actually provides rights to the original authors and creators of creative works. And when we say creative works, we mean like literary, dramatic, musical, artistic, intellectual, things that like we make, where we publish articles. And the idea is that they can control their work for a limited period of time. So copyright is extended to a selection of things, right? So to have something copyrighted, it must be an original work of authorship. It must be fixed, what we say, affixed in a tangible medium. So it must be written down or recorded or captured in some way. And it doesn't need to have the copyright symbol. So a lot of people see that little symbol and they think that, okay, this is copyrighted and I don't see it elsewhere. And they think that that's actually free to use. And that's not the case in the US. The things that can be copyrighted fall into a number of different categories, like I said, and this is just sort of a general list of what they would be. So as I said, literary and music, dramatic, things like pantomiming and choreography, sound recordings, pictures and sculptures, obviously motion pictures and recordings, but also computer programs, compilations of work. So when they put together a number of different things into a new edition, and then also architectural works. So you can see on the side of that's are some of the examples that, everything from a friend of mine kid's drawing to a scribble on a piece of paper can be copyrighted or is copyrighted. Copyright doesn't extend to a number of different areas that sometimes surprising for people. So while all those other categories can be copyrighted, there's a number of categories that cannot have a copyright or not protected by copyright. And that's things that we consider ideas and procedures and methods, or systems and processes. So if you've ever wondered why you can see so many recipes that went from being in recipe books at one time to being distributed online, right? Everybody can Google a recipe. It's because the process of making a peanut butter and jelly sandwich is not copyrightable. It's how you depict that with your images and your graphics that becomes copyrighted. So that's why you often will hear that recipe is a secret, right? They don't want people to know because that process is not copyrightable. Also, things like titles and names and slogans. So if I wanted to name my kid George Clooney, or the name of a car, Toyota Tacoma, those things are not copyrightable. You can get away with using those terms. You also can't copyright facts, news, and research. And underneath this research comes the data of that research. That is not copyrightable. So you can't copyright the fact that Barack Obama became the first Black president on November 4th, 2008, right? You can continue to put that into articles and cite that because that's not something that's copyrightable. You can also not copyright anything that's already in the public domain. So that means most work, not all work, by government agencies is considered in the public domain. So is the US Constitution, right? So that's why I can take pictures and recopy it because it's not copyrightable. Also, works that have already fallen out of copyright as the copyright law has changed, and I'll mention that a little bit more in a minute, but generally anything prior to 1923. And then anything that's not fixed in a tangible medium. So this lecture right now, my workshop, is not copyrighted until we record it. And then now the recording is copyrighted and can be owned. So when the ability to actually record started happening and making it easier for people to record other people, there was this whole discussion about, well, who owns that? That was my speech, but this student actually recorded it. Well, the person who fixes it in the medium gets the claim copyright. So there is some conflict sometimes that goes on there. So when you are a copyright holder, you have 6 exclusive rights that protect your work. So the first right is to reproduce, to make copies of your own work, copies of the article, copies of the poem. The second right is to distribute that work. So you can email it, you can post it, you can decide how that work is broadcast to the world. You have the right to make derivatives of that work. So you can have it translated into another language. You have the right to publicly perform your work, right? So if you made a film, you have the right to decide whether it's going to be performed at the Detroit Institute of Art. You have the right to display your work. So photography students want to determine how their work is used on a poster or an advertisement. That's the right that they're protected with. And then you have the right to publicly perform recordings or audio transmissions. So this is when works were started to be able to be recorded and captured. How exactly that is, the distribution of that is being done is protected by copyright. So this idea of streaming, right? So you have the right to decide whether your band's performance is able to be streamed on the streaming system. So when I mentioned the idea of the length of copyright, copyright in the United States is quite long. It didn't used to be, it kept getting pushed longer and longer, but the copyright essentially is affixed to a work until the author dies plus 70 years, okay? So what that means is there's a moving timeline of when things enter the public domain. And so you may hear these, usually around January, very often I'll hear on National Public Radio, they talk about the things that are now entering public domain that you can now access. And this has been a great benefit to places like Disney, where they have grabbed a lot of this public domain stuff and turned it into their own enterprise. So there is a moving timeline there. There's a few differences when it comes to whether it's a corporate author or individual author, but there are resources and tools out there to kind of discover whether something is under copyright. So the idea of copyright really was meant as intended for a dual purpose. It was trying to protect the work of authors and creators for a limited time so they could benefit off of it. But they also wanted to establish a way in which to promote creativity and learning and allow other people to build off of those works. Because as we know with art and a lot of other things, that a lot of things are inspired by other creative works, right? And if we can't use those creative works, then we can't promote arts and science and other original works to come from that. So this idea of allowing someone a limited monopoly of their work gets a little bit lost in the fact that we've extended copyright for so long, but they've built provisions into the law to allow people to use these works. And those provisions that we have that allow this type of what we call parody in this case of using things that we think, wow, that's copyrighted. How did they do that? Is what the hope was, that it would, allow for criticism and creative works to be inspired from other works. And so the built-in permissions that happen within the copyright law, there's several actually, but we're really going to talk about the fair use. So what they call the section 107 of the law. So obviously libraries have a number of provisions like the Librarian Archives Act that allows us to give out books for free to people when they check them out, or make copies of books when we're making copies of the chapters of those books. Some of that has been updated with the digital era, with the Digital Millennium Copyright Act and the Teach Act that has to do with teaching, that I'm not going to go into too much today because really we're going to focus on that fair use part. So what fair use allows us to do, and most of the time people think if I'm using it for education, it's under fair use and I'm good, which is not really the case. So there are provisions in there, but we need to know more of the nuances of it, okay? So fair use allows people to use, anybody, doesn't matter if you're in education or not, allows you to use copyrighted material without getting permission if you're doing a number of things. So criticism is one thing that you'll see. So a lot of times you'll see it in editorial pieces or the newspaper, right? That's gonna fall into criticism, or comment, news. So as we showed before, reporting, teaching, scholarship, and research. So obviously we're gonna fall in that teaching, scholarship, and research area, but you might be a scholar who's also doing some sort of criticism or news as well. And that's where that fair use would come up. So one thing that I would point out is that fair use isn't meant to be used on things that we consider consumables. So a test book, right? So the library, for instance, wouldn't be allowed to make copies of a test prep book for students. So while we can do that with other items, the idea is that the test prep books are consumables and we can't use those in the same way. It is supposed to be technology neutral, although with the changing technology of our times, the copyright is being strained a little bit as to how it's being applied. So we have to, when we think about using something that's copyrighted with the fair use, we have to consider a couple of things. And it's what we call the 4 factors of fair use. And I'm going to go through them and then we'll kind of look at what exactly that means in practice. But these are what they consider guidelines, and they're not explicit rules. So this is where determining fair use sometimes for people gets a little tricky. So the first thing that they look at is the purpose and character of the use of the item that you have. So if you're using something, what is the nature of your use? So obviously for us, we can say, well, my nature is educational or it's research, right? So I haven't determined what I'm doing. I'm not deciding to use that thing to make money and have it commercial. I'm strictly using it for research. So that one's sometimes much easier to determine than the others. So what is the nature of the copyrighted work that we're using? Okay, so if I'm using something that was developed strictly creatively, or was I using something that was informative, right? So if I'm reusing something that was already meant to inform people for research or for educational purposes, it really leans towards fair use more than if I'm reusing a creative work. And creative work, we'll talk a little bit more about why those get a little bit more tricky. And that comes under this idea of the amount and substantiality of the work. So when we're thinking about fair use, that is really saying how much of the work are we using? Are we using the entirety of the work or just a portion? So that's easy to apply when you have something like a book. So I'm only using one chapter of the book. Could seem that that's a very fair use to do. But when you're looking at something like a photograph or a painting, it's very hard to only use a portion of it. You have to use the entirety of the actual photograph or painting usually to represent what you need. So that's really going to be considered. It's going to have to, you're going to have to think of it differently based off of what type of work you're using. And the fourth factor is the effect of your use on the potential market for that work, right? So are you using something that, and the way in which you're using it may impact the copyright holder from being able to make a financial gain from it later. So those are 4 different things that are considered. And again, it's considered a rule of reason, so that not one of those factors is more definitive than the next, although courts often will weigh certain factors more depending on the use. So they're, really, they would look at the intent. If it was clearly a use that looks to be exploitive, like they're just literally just taking that use and repackaging it so they can sell it, that individual factor is going to weigh heavier for the courts to say that is a violation of copyright. So they consider that not to be a transformative use, but to be parasitic. So really when a case is being argued as to whether it's fair, they're looking at, is the use transformative? Has it been used in a different way? So if you're using a creative work and you're using the entirety of the creative work, are you using it in a different way than was intended? So this is an artwork or even a movie, which is always very challenging, right? So a professor wants to show it an entire movie to the class, but they're using it so they can analyze the actual movie and analyze the technique. So that's going to be different than the original intent, which would essentially be to entertain. So again, the fair use is considered a rule of reason, and this unlicensed use, as they call it, so you haven't actually contacted them and got a approval and got a license for it, does it add significant value, right? So is it exploiting, as I mentioned earlier? So is it adding value to what people can see and the public can use? Is it adding some additional thing that wasn't there with the original? Was it done in good faith? So oftentimes people will use a copyrighted work, and they may have even tried to contact a copyright holder or who they think is the copyright holder, but they were never able to do that. So there's a lot of works of that are copyrighted that are considered orphaned. We don't know who owns the copyright. So if there's been a good faith effort to do that, then they will consider that as well. And this idea of, was the use considered reasonable to the general opinion? And the general opinion will change by the discipline, right? So what is used in media studies is going to be different than what might be used in biology, right? And so this idea that if your peers would consider this a reasonable use, that they're going to look at that as a case. And the reason that's really developed is that there's been these rules of practice that have come out of different disciplines, which we'll talk about in a minute. But really what it comes down to is that if we're using a work that is copyrighted and we're trying to claim fair use, we really want to weigh that on how transformative of the use that we're doing. So how much are we repurposing it from its original use? Are we just using it the same way, or are we using it in a different way? So that's kind of the overview of copyright and the use of fair use within copyright. Now, there is a lot of material that's available that is not copyrighted, or it's copyrighted in a way that allows for use. And this is done in a number of different ways. So open access literature. So if you're a researcher who has been researching and found these open access literature, you will have seen this before. And the reason that you can use that is because they have licensed it as an open content. So they still own the copyright, but they said, I allow this to be distributed and everybody else to be able to distribute it as well. And that's done through something called a Creative Commons license. And so you may have seen these licenses on different items, but essentially what that is it's the original creator telling the world how they allow their material to be used without people having to contact them. So they're not giving up the rights to the work, but they're allowing it to be what we call openly licensed. There's also the public domain work that I mentioned. So things in the Library of Congress that there's lots of historic images and documents that all come up through that public domain area. There's materials in library subscription databases. Some of it will be able to be usable, particularly if you're including that in your research or thesis, and some of it will not. And some of that will depend on the license that we have with the provider. So for instance, JSTOR, which is an art database, has a lot of art images in it. Those images in there specifically are licensed to us for use, but not for use in dissertations. And so if that's something that students are looking at using, they really need to work out how they're going to include those images. The library also has guides for how to find different types of openly licensed material, particularly images. So this idea of an alternative copyright, so these Creative Commons licenses are things that you will come across through the use of different items that you will find out there, but you also will come across as an author and publisher. And so more and more journals are starting to publish with these open licenses. And so we have quite a bit of information on our library website about what the licenses mean and how to apply them. So I'm not going to go into great detail about the licenses here. But as I said, you will find openly licensed Creative Commons with open access literature, with open data, charts. So Figshare is one place where people have seen a lot of these different charts that they come from. And so those are openly licensed items that can be used in our research and in dissertations because they already tell us how we can use them. And the licenses specifically tell us whether they're completely open, or in this case, you can see it listed here, I have a CC by NC, which means it can be used, but not for commercial purposes. So we have to check that license to make sure we're using it properly based off the license of the item, but we don't have to contact the copyright holder to do that. So the idea of this fair use and how different disciplines use fair use, as I mentioned earlier, would someone in my discipline consider this to be fair, was something that the academic and educational community wanted to solidify a little bit more. And so what has happened is they've developed these fair use guidelines in different disciplines, and they've published them in a number of different areas. And this started with actually, I think, the use of video and media. So video and media scholars really needed some guidelines as to what they can use because all of that content is copyrighted. And so you can find those guidelines on the Center for Social Media Best Practice Guidelines. And I have them linked on websites at the library as well, and all of these different tools that allow you to find that. There's also a lot of tools available out there that just kind of help check through. They call them fair use evaluation checklists. And so you can just step through the checklist and see if you're doing all of the right things and determining whether what you're doing is fair use. And then it's always really good to hold on to that, because that's that idea that you did your due diligence, that you actually thought through the process and showed that you were not just using something, but you thought about whether it was okay to use that item. If by chance something copyrighted has to be used, there's obviously a process for that as well. And there's a number of ways to do that. There's a place called the Copyright Clearance Center that is essentially a website where you can make an account and you log in, and it essentially mitigates the payments for different types of copyrighted material. Very often, if you're submitting to a journal and you have what they consider copyrighted material in there, they may ask you to go through that process. I would argue that you should at least maybe contact me or someone else who has some expertise in copyright and fair use to make sure you actually need to do that, because journals often will push people off to do that when they really don't need to be doing that. But there's usually a payment involved. And so you want to make sure you're not paying for something that you don't have to. There's also a motion pictures and licensing corporation that handles all of that has to do with movies and performances. So if there's works there that are copyrighted that you have to ask for permission from, these different agencies kind of are the in-between for the copyright holder and the person wanting to use it. Some of the advice that I give is that if you have to obtain permission, whether it's through the Copyright Center or sometimes you can actually directly contact the author and get permission from them or the creator, that you just want to make sure that you have something in writing. So if you're obtaining permission, that you get that in writing, whether it's an email or some other way that says that they gave you that permission. It's something that you both have a copy of, so that you know, if anything comes up later, or if the publisher that you're working with needs to see that, you have that. And if this is the case, you have to actually request copyright clearance, you really have to allow yourself a substantial amount of time to do it. So it's not something that's going to happen in a week or two, because you need to determine very often an author will say, well, yes, that's my work, but I don't own copyright to that anymore. That's owned by X, or, you know, this publisher or this other person. And so it's going to take some time to track down who actually is the copyright holder and who can give that permission. So now I'm going to pivot and just kind of wrap up talking about you as a copyright holder, right? So all of us, regardless if we've ever published anything, are copyright holders. So every email you send, every little doodle you make is actually copyrighted, which seems crazy, but that's true. And so we all hold exclusive licenses to our own work. This obviously becomes relevant as scholars, we are going to turn towards thinking about publishing the research that we are doing, right? And so we want to make sure that we're making good choices when we're doing that. So a traditional license from a publisher will be what they call an exclusive license, which means you are essentially handing over your entire copyright to that person, that company, whoever it is. So you no longer own the copyright to your own work, and you can only use it under the provisions of fair use. So that's the standard format for most publishing these days. And you can see I put a little quote in there from a Springer author's agreement. It's directly picked up from their author's agreement. And so you won't be able to reuse your own work in any way without direct permission from them or for what falls under fair use. Now, sometimes they'll have a clause in that will explain different ways that you can reuse it, but essentially it's no longer your work. So there's also a second way that we might be working with that is there's a transfer of some rights. So the publisher or whoever you're working with might ask for you to transfer certain rights to them for a limited time. So you have the right to perform this work of mine for this amount of time, but you actually retain your own copyright in that. And then the third option is that you license your work, which is the desirable way to do that. And that's how the Creative Commons licenses work, is that you license the right for the publisher to use your work. And usually that's, they can be the first person to publish it. They're allowed maybe to translate it and those different types of uses, but you actually retain the copyright for your work. And that the license that goes on there is usually what we call a Creative Commons license, and you define how that's being used. So those are the three different ways in which you would control or give away the work that your scholarly work or your intellectual property right. So what I advise is that before you contact a publisher to publish or a journal, that you find out what their author's rights agreements look like. And there's different ways to do that. And if they are already open access journals, then they are going to have Creative Commons licenses, which are authors friendly. But if you're not sure, there are different tools, and I'm the scholarly communications librarian, so I am more than happy to help with that. But we also have liaison librarians in the different disciplines who can help with that as well. When it comes to things beyond just the traditional journal, when we think about books and book chapters, copyright works, the same there, but the way in which they're licensed might be different. Or you might decide that you have a journal article that you've already published that you would very nicely turn into a book chapter, and you want the ability to do that. And so as you are looking at the license that you have to sign, and typically it's the last thing that you're given. So you've gone through submitting something to a publisher and maybe reviews and changes from peer review. And then the last thing you get is that agreement. So you may not see it unless you've asked up front to be able to look at it. Are you able to turn that into a book chapter later on? So if you think that you're going to want that, or translate to another language. I had a faculty member come to me and they're native Chinese, and they wanted to be able to translate their own work into their native language. And so they made sure they wrote that in their contract. So essentially it's a negotiation, which a lot of people are like, oh, I don't know if I want to do that. Well, if they've already accepted your work, they're not going to decline your work just because you want to negotiate different rights. So they've already put all of that work into there. So you might as well ask for what it is you want and what you need up front, because asking for it after publication is much harder. And you can have those things added on as author addendums, or they just write it into the different agreements. And surprisingly, the publishers do have these different levels of agreements, and they're going to give you the agreement that they want first and hope that you accept it before they give you a more loose agreement later. So at the end, I just like to present some scenarios and have people think about that. When we were face-to-face, we would kind of sit around and talk about this as a group and stuff. So I'm just going to present the scenarios and kind of we'll think it through, and then we'll wrap up. But so if you or a friend at another university, say you have a colleague from another university who emails you and ask for a copy of a recently published article in which you were a co-author, would you share that work with them? So if we think that through and we think about the copyright implications, the questions that would come up that I would ask is that, well, it depends, right? It depends if you signed away your copyright to the publisher for you to be able to do that, right? So, and very, very often, you've already signed away the right, but they may have told you within that copyright agreement how you're able to share it, maybe just amongst your friends or with your students, right? So the answer with that would be, it would probably depend. Now, in most cases nowadays, people go ahead and share that. But as a person with copyright experience, I know that you would at least have to pause and think about, has that, have I already given away my rights to that work? So you're including pictures that you found on the internet in a conference presentation, okay? And is it okay to use them because we're not being paid, right? So most people I know, especially with the advent of PowerPoint, we just slap a lot of pictures on those PowerPoints that we've grabbed from online, and we don't really think about that. I mean, as a librarian, I've always given credit to the people because that's what I teach, but people don't really consider that, well, why can't I just add that image to my PowerPoint presentation? And so if we consider that, again, in the idea of fair use, that again, I would have to say it depends. So if the presentation is only going to happen within the 4 walls of that conference, and it's not going to be made available online, which nowadays oftentimes they are, whether the actual slides are online or they're recorded and broadcast online or distributed or printed online, that's going to change whether we should be able to do that. So if we're just within the confines of the conference room, putting up those images probably isn't going to be too much trouble and could be considered, fine, maybe under fair use. But if those things are going to be published, then we really have to consider what images we're using, because we're republishing someone else's work without their permission. And so then we would want to make sure that the images we use are openly licensed images and not some famous copyrighted image that we're now republishing. So I think I actually kind of gave this one away earlier, but so can you use images that you created or found in the library database in a dissertation? Again, it depends. So it depends on the database, it depends on the images, and it depends on how they're licensed. And so very often we do have graduate students who want to incorporate some images that they have found there. And we really need to look at them individually and find out where they came from before we can make that determination. And the last scenario that I have is a little trickier too. So a colleague used data from your lab experiments without asking and then distributed the results. So other than the fact that this colleague maybe isn't, the best professional manner, and you're, thinking, well, can I trust this person? Can you take legal action against them? Is there something that you can do, right? So if we think back to the number of things that I discussed that can't be copyrighted, data is one of them, right? So the actual raw data that hasn't been analyzed and presented in some way that you have given your intellectual and creative property to isn't copyrighted. So if someone was to take that data and use it, they can do that, which is often why people like to keep that data safe until they're done using it, right? So there really isn't anything legally we can do with that. Now, is there something that they did ethically that was wrong? Probably. And so looking at the ethical standards within their discipline, within their area of practice, is important to consider. And maybe that would be an approach to just dealing with that issue from the ethical issues, looking at the principles for their community of practice. So just as an overview, fair use is a way in which we can use copyrighted materials in the things that we do as academics and researchers and teachers. And we really just have to step through this process of considering what is the nature of our use that we're doing that. And we have a great ability to use copyrighted works in many different ways, but we have to be conscious of what we're doing with our use, how we're, especially now with everything being distributed online, and essentially being published, we just have to give some consideration to how we're using that work. So with these slides, as I make those available, we'll have all of the links to some of the resources that I mentioned, as well as some places to find the fair use checklists and the length of copyright and all of that type of material that could be helpful as you're stepping through that. I also have my contact information, and I'm always available for appointments and individually talk through different scenarios with people as they're working in their research and their dissertation and different things like that. So that is my entire presentation. If anybody who is attending here wants to ask a question or wants some clarification, I am totally open to doing that in the last, we got a few minutes here that we have.
Great, thank you so much, Julia. We do actually have a couple questions in the chat, so I'm going to begin with the most recent one. Who enforces fair use, and is it costly to enforce?
That's a great question.
Mm-hmm.
So enforcing the fair use essentially comes down to the copyright holder. So if somebody sees that you violated my copyright, they would then have to do a legal action through the courts to say, I don't believe this falls under fair use. Okay, I believe that this is a violation of my copyright, and it would go through an evaluation through the courts. So it's really up to the individual copyright holder, which is part of the reason why, I mean, when YouTube first came out, I was like, how does this exist? It's like all copyrighted material, right? So that's a part of the reason why you see a lot of copyrighted material out on the web, is that it's not enforced by some entity, it's up to the individual copyright holders.
So it can then be costly to enforce because of the legal system. And then it's more of a personal financial burden. Is that what I'm understanding?
Yes. Yeah. So, and I guess that goes, I should point out that we do have a copyright mini course if people are really interested that they can go through that gets really into more detail about different things. But the idea of registering, so if you're a lot of creative people like to register their work, because if you have that registration with the little C on it, then you have a better standing for enforcement because you've registered it. You don't need to register to enforce it, but you at least can say, especially in those issues where someone else is like, well, that's my work and there's no proof of who made it first, right? If that person had registered it, then they have that proof. And that's a pretty easy process, but it does cost some money to register a work. Not a lot, but it does cost.
Another question. I see movie snippets compiled into summary videos with critic comments and captions. Is that legal?
Yeah, so Disney would say no. Disney really does not like that. And actually it's interesting because I have two 10-year-olds who now know how to do all this, and they keep saying this is going to get flagged for copyright, and they don't quite understand what's going on. But in some sense, yes, what they're using there is fair use because it's commentary, right? It's criticism or it's parody. So my kids really like the ones where they put the different Frozen and all these different Disney movies together and they sort of make funny things, make them do funny things. And they've asked me, how do they get away with that? And it's because it's falling under that fair use of parody and news and criticism.
Interesting. Seems very, very much a gray area right there with the parody. Interesting. Yes. Do we have any other questions? I see. Yeah, there was a comment. There are a ton of critic videos I see in Chinese posted on YouTube with high view counts based on something you said. I think that's all the questions within the chat. Anybody else? Feel free to unmute yourself or put them in the chat and I can read them aloud.
I'm going to stop sharing. Grab my share here.
One individual wants to know how to register or find information about the mini course.
Oh, okay, I can share that.
Great.
Right here. I think it's in here, and if it's not, it should be. Copyright, yeah, I'll make sure I share that. So let me pull up my chat. So those are my slides. Oops, and we can also share the slides as a follow-up as well, but
thank you.
Let's just share those. So the mini courses, I'll pull up from the library. Oh, I am still sharing. Okay, good. I have so many of these. It keeps putting all these windows on top of my bar. Okay, so in the library, this is going to be changing. But as for now, if you go under tutorials, you'll actually see our mini courses here. So we do actually have, that's where the plagiarism one, if you ever had to do that before, was. So this is the copyright one. So it's a short course that you step through and it gives you scenarios based off of your copyright holder or your copyright creator. those different things. And it does discuss about registering and that type of thing in there. There's also a resource guide, I believe, because there were so many good links. Yeah, this is all the resources that are linked to inside the course, because people have asked, so you can see here that there's different ways to link to that. One thing I didn't mention, just because there's so much to cover in this thing, but there is something called the work for hire. So in some institutions, not at Oakland, and the capacity as a faculty member, now with staff, this might be a little bit different, is that if you're hired by an institution, particularly like government institutions, they own the copyright to the work you create. So as a faculty member, the work that I make in my research and I publish is mine, but that's not the case at all universities. And that's not the case for all positions within, the university. So if you're someone in communications and marketing, they don't own the copyright to the creative things they make, the university does. And so that's an additional kind of gray area with copyright. And that's covered a little bit in that.
I've had some interesting situations with friends who learned that way, or learned that the hard way with internships. Yes. Even within unpaid internships, your material is not yours.
Yep. So it's very good to, it's good to clarify that going into, especially I've had students come to me who are grad students of researchers as well, or different areas. And so it's really good to kind of clarify just going in. Some of that might come under copyright and the work for hire, or some of it might be like, again, those sort of standards of practice within the discipline, right? As to who's an author and who's a creator. And a lot of the standards of practice are very clear. Like if you gather data, you should be listed as an author. And so therefore you would claim copyright as well to those things. And so there is a lot of, but that's not the case in every discipline. So it is good to know that going in, to ask up front.
Very interesting.
Helpful.
Yeah. Thank you so much. If any of the individuals have any questions, feel free to hang around a couple minutes. Otherwise, we'll close and I'll stop recording.